Alan, we can go ahead and get started.
Very good. Well, I'd like to introduce myself. I'm Alan Steinbrecher, and I'm the chair of the State Bar of California this year. And on behalf of the State Bar and the members of its Board of Trustees, I want to welcome all of the applicants who are attending this meeting this morning. As you can imagine, and we know, the administration of this California bar examination is of the utmost importance to the bar and the Supreme Court. We take our obligation to administer this bar examination very seriously. But we all know that it's a year like no other, and we understand the circumstances that surround the decision the court will ultimately make concerning the administration of the exam this year. We are committed to doing everything in our power to carry out that decision appropriately. And we're here today to listen to your concerns and thoughts, and we appreciate the time that you are taking to join this call. And before we begin, I'd like to make some introductions. We're honored to have with us today the Chief Justice of the Supreme Court of California, the Honorable Tani Cantil-Sakaue. We also have the Honorable Goodwin Liu and the Honorable Mariana Florentino Cuellar, justices of the court. We have, in addition, the court's lead attorney, Greg Fortescue, and the Chief Justice's principal attorney, Neil Gupta. Joining me from the Board of Trustees is Sean Saleg, our vice chair, Josh Pertula, the chair of a special board committee overseeing the preparation of the California bar exam this year, and Mark Broughton, a member of that special committee, also a member of the board. From the Committee of Bar Examiners, we have Alex Chang, who is also a member of that special committee. And from the State Bar staff, we have Donna Hershkowitz, our interim executive director, Amy Nunez, the director of admissions, and a number of other key members of the State Bar staff in the admissions office. Now, I'm going to ask the bar's executive director, Donna Hershkowitz, to conduct the meeting. Donna.
Thank you, Alan. Thank you to all of the attendees who are joining us today. I want to welcome you and just talk very briefly before we turn it over to the most important part of the day, which is getting your input. I think we have two primary goals today. The first is to provide information to you to demystify what an online exam might look like, should that be the direction that is ultimately determined to be the most appropriate. We hear comments about internet connectivity and bandwidth that may be less relevant for the bar exam based on the plans that we've established. We read about concerns about virtual scratch paper that may be diminished by the efforts that we have taken to increase access to scratch paper. We hear concerns about technical issues that are considerably reduced based on the methods that we are planning. And we have heard concerns and we've made changes where necessary and appropriate and possible. We have also learned from the overall positive experience with the first year law students exam about things that can and have been and will be improved to make the applicant experience better for the bar exam should we be proceeding with an online administration. But our second goal today is to hear from you, to get your input on the challenges of an online or in-person exam, and to get your suggestions for moving forward with licensure in 2020. As Alan mentioned, all of us find ourselves in incredibly difficult times right now, having to do things that we never thought we'd have to do, and to think about different ways to operate. Bar licensure in 2020 is most certainly one of those things, but it is, of course, one of the more high-stakes items that we need to handle, and we need to handle it correctly. I'd like to have Amy Nunez, the State Bar's Director of Admissions, provide a little bit more information for you about the applicant experience for an online administration that was based on the experience that we had with the first year law students exam just a couple of weeks ago, as well as provide you a little bit more detail on the issues that we're exploring and the challenges that we believe we've overcome for an online administration. With that, I'll turn it over to Amy.
Thank you, Donna. Good morning, everyone, and thanks for being here today. I'm going to start a little bit on the review of the first year exam experience, and then I'll talk about the considerations that we have for the upcoming bar exam. So on June 23rd, the State Bar held its first online examination. The first year law student exam, among other things, served to help identify any issues with the platform, the delivery of the exam online with remote proctoring, and to determine if we can scale up from a small number of examinees to a large number. We also ensured that our current vendor is able to host as many people as possible. So we're working with a vendor that's hosted a remote exam for up to 160,000 applicants that were all synchronized with the same start time. So for the first year exam, overall, the exam was successful. We had 279 applicants that took the exam online remotely. Nearly all uploaded their responses to each of the 6 segments of the exam immediately after each segment. So here's some lessons learned that we want to apply for the bar exam. ExamSoft is planning to host a dedicated telephone line for any technical questions needing immediate response during that exam. During the exam of the first year, there was a phone tree that people had to cut through, and so we're hoping to have this dedicated telephone line, or planning to. Exams passwords were also need to be displayed more prominently on the ExamSoft landing page, and its location will be highlighted in the announcement video and in the written material once more and more prominently. Some of these issues that have been raised and are under consideration, we've talked a little, Donna highlighted, the lack of strong internet service and having sufficient bandwidth has been a concern. So unlike the LSAT and other online administrations that we've been hearing about, the setup for ExamSoft we're using does not require continual uninterrupted internet service. What is required prior to the exam is internet access to download the software. And then on exam day, an internet connection is needed only at the start of each exam session to conduct the facial recognition at the start of each question. And once that process is completed, applicants can begin the exam and the internet connection is disconnected. Once an exam session itself, after each question is completed, the internet connection is reestablished and the applicant's exam file is uploaded. So the exam file is a text file and doesn't require high-speed internet to upload quickly. So a minimum upload speed of 2 megabytes per second is required. However, if it's necessary, we will allow an on-site exam administrations for those people with extenuating circumstances, in addition to those that require a TA that does not lend itself well to remote proctoring. As for computer access, the COVID crisis has made the world more reliant on technology in a variety of ways. For law schools have persevered by providing online course instruction, which require that students have access to laptops with cameras. For exam applicants, where this might be a problem, that is laptop access, we will allow on-site administration. We talked about the virtual scratch paper, and this is something we've received a lot of feedback about, and obviously something very important that we need to address. The first year law student exam used virtual scratch paper, and based on comments received from a post-exam survey that we conducted, examinees noted that this was challenging. So we recognize that using virtual scratch paper may be further challenging also for the performance test, especially given that it has a character limitation right now of 1,072 characters. So ExamSoft is attempting to increase that character limitation, and the State Bar is also exploring several options related to the administration of the performance test portion of the exam. So overall, the first year exam has provided opportunity to examine where we need to bolster our efforts. One measure that should be of interest to exam applicants is that we want to develop a practice module that we're working to develop with ExamSoft. We plan to load previously used bar exam questions, and this includes essay questions and performance test questions to allow applicants the ability to practice with the actual system and with actual questions prior to the exam. The last item that I want to highlight with applicants is communication about the exam. And this is very important, especially concerning the registration and the next steps for applicants. So I personally want to encourage all applicants to continually check their AIMS portal and their email for notices related to the bar exam. We plan to develop a frequently asked questions section about the upcoming exam on our website, but we also want to reach out to applicants, and we'll keep you updated as often as necessary by reaching out to applicants. So this second method of communication is direct emails to applicants. We plan to reach out using the email registered in the Ames portal. So in order for this to successfully communicate, we need to ensure two things: that applicants have the correct email, one that they access on a regular basis, noted in their portal, because that's the email that we'll be using to reach out to applicants, regardless of whether you're in California, the United States, or out of the country. We're going to reach you through that email address. Secondly, applicants need to check their email from the State Bar weekly from this point forward for any updates. And as we get closer to the exam, I recommend that emails get checked daily for any things that might change. Circumstances change, and we want to ensure that you're all kept apprised of the latest issues that may be impacting the exam administration. So again, to do so, we plan to put information up on our website in the form of this FAQ, and also to email applicants through the portal. All right, thank you.
Thank you, Amy. At this point, I would like to open up the meeting to take input from all of you who are attending. I have an airplane in the background. If you can hear that, I'll be closing my window in just a second. For those of you who are new to this format of a Zoom webinar, there is a raise hand function at the bottom of your screen for the attendees. And if you are calling in by phone, dial *9, and that will also allow you to raise your hand. We will call on you one by one. We've allotted 1 minute for your comments. When I call on you, staff will give you the microphone and unmute your line. And when you start speaking, that's when your 1 minute will begin. And so let's go on ahead then and get started with, and I apologize ahead of time for names that I may pronounce incorrectly. Let's start with Dominique Boubion. Devin, if you can give Dominique the mic.
Hi, can you hear me?
We can. Go ahead, Dominique.
Yes, my name is Dominique. I am one of the authors of the 440-page report that was submitted to the Supreme Court and State Bar, and I'd like to deliver a piece of data. 91% of the survey respondents are currently experiencing hardships in the form of financial insecurity, housing insecurity, and food insecurity. So it's not surprising to find that 81% are also struggling emotionally. The decision to postpone the bar has strained applicants' finances while simultaneously curtailing the opportunity to look for a job and make money when they need it the most. Passing the bar this year has significant financial implications, yet test anxiety is at an all-time high over the uncertainty over the testing process. Over 80% of respondents reported that they are uncomfortable with taking an online exam, and studies show that test takers that are unfamiliar with the testing process exhibit higher levels of test anxiety and resulting in lower academic performance. In short, we can expect that this will negatively impact bar passage. Thank you.
Thank you, Dominique. Dominique, if you can lower your hand now, and we will turn to our next commenter, Ms. Pilar Escontrias.
Yes, good morning. I've also arranged for United for Diploma Privilege to pool their time previously with Ms. Hershkovitz. So there are 10 individuals who have yielded their time so that I may present.
If you could just let us know, Ms. Escontrias, who are those 10 individuals on the phone now who've yielded their time?
Absolutely, my apologies. I had emailed it and I did not put it up in front of me. Okay, here they are. Me, Loveline Purewall, Miriam Carr, Guillermo Navarro Galindo, Kristen Keto, Ted Mumford, Octavia Carson, Alyssa Lax, Savannah Wadsworth, and Andrew Sucato.
Thank you, Ms.
I'm sorry, they have also, they should be lowering their hands now.
Perfect. Thank you, Ms. Escontrias. Your 10 minutes will start now.
Thank you. Chief Justice Kantil Sakaue, Justice Cuellar, Justice Liu, distinguished representatives of the Supreme Court, and members of the State Bar of California, thank you for providing us with time to present before this body. My name is Dr. Pilar Margarita Hernandez Escontrias, and I'm here to speak on behalf of 2,000 JD and LLM graduates, practicing attorneys, and professors who are united in our mission to secure emergency diploma privilege for all who have registered to take the July 2020 exam. We distributed our survey in late June, and in the past 2 weeks, more than 1,400 applicants filled it out. The data presented reflect roughly a 15% sample size of all known test takers set to originally take the July 2020 bar. As noted previously, we submitted a 467-page report to the Supreme Court and the State Bar of California, where we detail our findings, which are clear. Should California insist on an online administration or an indefinite postponement, projections for diversity in the legal profession post-COVID-19 will see an overall statistically significant decrease. There will be fewer attorneys of color, fewer attorneys with disabilities, fewer attorneys who come from immigrant backgrounds, fewer first-gen attorneys, and because of our extensive research and survey, we can highlight these reasons. First, we would like to discuss the detrimental consequences of an online exam and be clear that the technology to carry out same-day remote proctored tests, or RPTs, on the scale of the bar exam does not currently exist. COVID-19 has led to a massive demand for RPT services, and vendors are scrambling to meet this demand. The State Bar of California's test vendor ExamSoft went from an RPT space customer base of 8 to 500 just this March, a mere 3 months ago. We respect what Ms. Nunez has related and are anxious to hear about the truly extraordinary results that your vendor has been able to achieve, and in what we hope to be an open, transparent process. We'll be interested to hear of what Ms. Nunez described involved the 40,000 human vendors that the vendor arranged that are necessary under the State Bar 1-to-4 proctor examinee ratio per pilot program specifications. To be clear, the necessary pilot program has never been achieved. As we detail thoroughly in our report, an online administration is technically complex. One only need consider what happened when the medical qualifying exams in Canada decided to hold an online exam. This examination had only 2,300 examinees, 1/4 of what is proposed here, who were remotely proctored for a 9-hour exam given at different times over the course of a 4-month period by a US vendor. This has been a series of major failures, including examinees having to recheck in with the proctor multiple times throughout the day due to server disconnection and premature conclusion of the tests. We must highlight that ExamSoft's Exam Monitor software just finished beta testing in March with 8 customers on it. For clarity, beta testing is an opportunity for real users to use a product in a production environment with a goal of uncovering bugs and general issues so they can be addressed before a general release. Another example can be found with the College Board, which administrators advanced placement tests, the SAT and the PSAT for high school students. They are currently facing criticism and a class action lawsuit over the online administration of its AP exam due to inability of examinees to upload their completed examinations. The AP and GMAT tests were individually scheduled, meaning not all examinees were scheduled to take place on the same day at the same time, unlike the State Bar's proposed simultaneous administration of the bar exam for 9,000 to 10,000 examinees. After making categorical assurances of the viability of an at-home simultaneous mass-proctored SAT in April, the College Board discontinued the at-home SAT in June, simply because it was not feasible. No one can underestimate the discriminatory impact of an online administration. First, the offline version of the proctoring software requires significant processing and storage capacity that will not be available on everyone's machine without causing system failure. For example, a user with upwards of $6,500 to afford an 8-hour uninterruptible backup power supply and failover router with multiple backup wireless internet connections, so that if her primary internet connection fails, is at an obvious advantage over other users without access to this additional equipment. Additionally, remote proctoring, as discussed today, the Exam Monitor technology, is a combination of remote human proctoring and AI, which brings up technology, privacy, and bias concerns. By allowing access in the recording of examinees' private biometric information, the State Bar and California Supreme Court would allow for potential bias because it is well established that AI technology is developed and tested using datasets and biased human training inputs derived from white and frequently male subjects. Technology bias and privacy interests must be something this court and the State Bar take seriously. The data we collected in our impact survey bring these concerns into sharp relief. 72% of our respondents reported that they either had no access to reliable internet or that they were unsure as to whether the access would be reliable per the Bar Committee's standards. Additionally, more than 3/4 of survey respondents, that's 76.9%, reported not having space or being unsure of whether they will have the required space to participate in an online examination. To reiterate, less than 30% of respondents are sure they will have reliable and consistent internet. Only 23% are sure that they will have a quiet space where they can take an online exam. Even in a best case scenario, they will be asked to participate in an online examination that adds a further layer of bias to a system that already has an exclusionary impact on historically disadvantaged groups. What may be referred to here as, quote, technical errors is really a form of racialized test bias. Postponement to a date uncertain is not a legitimate alternative either. Based on our impact survey, attorney applicants are severely struggling in the midst of this pandemic, and the data are even more abysmal for people of color. This really should not be surprising, given that COVID-19 is in every articulable way more heavily affecting people of color. Just 2 days ago, the New York Times reported that Black and Latinx populations are 3 times as likely to become infected than their white neighbors. We are also twice as likely to die. I know that several of my co-authors on this call will share data points during their brief 1 minute before you, but I feel it's critical to stress a few statistics. 91% of respondents reported experiencing hardships. 81.9% reported financial insecurity. 35.9% reported housing insecurity. 12.6% reported food insecurity. The rate for each of these metrics among Black, Latinx, and Alaska Native or American Indian graduates is 10 to 27% higher than the overall rate. 50% of respondents reported that either they or someone in their household are considered high risk, according to the Center for Disease Control Guidance. When asked whether they have other obligations besides studying for the bar exam, 66.1% answered affirmatively. Nearly a third of those surveyed stated that they were participating in organizing and social justice causes. In our report, beginning on page 59, we offer several suggestions for how diploma privilege may be enacted. If we are truly a self-regulating profession, then what better way to enact that principle than to issue diploma privilege, which can include supervised practice by experienced attorneys, additional MCLEs, etc. Diploma privilege must truly be for all, or else this profession's promise of access to justice and equitable entry into the profession rings hollow. It must include non-ABA accredited graduates, many of whom come from historically disadvantaged backgrounds and who made affirmative decisions to go to law school that provided them with the flexibility to pursue a career of their choice while simultaneously supporting families and not becoming overburdened with debt. It must include non-2020 graduates. Some of these individuals are practicing attorneys in other states. Some are repeat test takers whose ability to practice law is best evidenced by their work ethic and their compassion toward their clients. It must include LLM students whose lives will surely be affected should they not achieve licensure quickly. There is little doubt that ICE will quickly target these LLM students for deportation the minute that a student visa or temporary work permit expires. Just yesterday, ICE announced increased enforcement efforts that target foreign students and announced that it will halt existing exemptions for student visa enforcement for all students who will be attending undergraduate or graduate programs online in fall 2020. As a social unit, lawyers are conditioned to accept the presumably universal truth that the bar exam measures competence to practice law, that they have stopped asking themselves whether it's the humane option given the circumstances in which we live. Our deans support us because they recognize the present dire circumstances. Our legislators support us because they want to ensure legal services are delivered to California's most vulnerable. Please show humanity and remind us why we felt so proud to envision futures as attorneys. And please remember, even in the best of times, scholars and practitioners question whether the bar exam is a test of minimum competency. In the times of COVID-19, this is simply a test of who has resources. Thank you.
Thank you, Mrs. Contreras. Just one comment that I wanted to make. Some of your concerns about the online administration related to the assumption that the proctoring would be live proctoring at the time of the exam, which is something that creates, understandably, some of the concerns about internet connectivity and bandwidth. The approach that's being used is not live proctoring, which allows for lesser requirements for internet connectivity, as Ms. Nunez described. There are recordings that are being done, which also changes the need for that 1-to-4 ratio that you had identified. That ratio for the pilot project assumed that we would be having live human proctors as opposed to recordings, which are then subsequently reviewed by live proctors. So that is a change that I just wanted to make sure to point out. Next, let's move on to our next commenter, Ms. Alyssa Shire.
Yes, I'm here. Can you hear me?
We can, Ms. Shire.
Thank you. I appreciate the court's time in this matter. So I'd like to briefly respond to your proposition, Donna, about the not live proctoring of the tests. We have addressed this in our report. Even without live proctoring, there are severe concerns about vendor reliability and vendor capacity. So I would encourage the court to read the section that we have addressed specifically on non-live remote proctoring. Second, I'd like to address the lost jobs and lost wages that the bar's decision to delay the exam has been causing for students, especially students of color. The majority of job offers held are contingent upon sitting for the bar. Over 81% of respondents reported that employments offered are contingent upon passing the bar, and over a quarter of these respondents said their current job offers would be rescinded if they cannot become licensed. Bar applicants are losing more than 5 months of salary, even with a September administration, when we will not get results until after January 2021. Respondents have reported that employment offers have been rescinded, not necessarily because of COVID, but because of the uncertainty of the bar exam administration and licensing process. One respondent reported they had already lost a position they were offered because the organization needed someone to start by the end of the summer. As a result of the continued postponement of the bar exam, over 73% of respondent surveys reported that they would be forced to take a non-legal job if the bar exam is further delayed, destroying our dreams that we have shaped our lives around for many years to become a lawyer. Additionally, I'd like to highlight that multiple respondents mentioned anticipating defaulting on student loans or preparing to declare bankruptcy on their mortgages or rents as a result of the indefinite postponement of the bar exam and the inability to work.
Ms.
Thank
Shire,
you.
apologize. Oh, thank you.